I don't play games. We don't play games here. You don't get to be put on a tether. Well, first of all, be told that you should not be contacting the victim and then finding and manipulating ways to do so. Don't do it here. Doesn't happen. Won't happen. Court calls case People versus Marquise Hankey.
Alexander, on behalf of the people, Your Honor.
Good morning, y'all. Attorney Kevin Bassant, P71061, on behalf of Mr. Marquise Hankey. Mr. Hankey, state your name for the record.
My name is Marquise Hankey.
Buckle up, guys. Today we're stepping into a courtroom where the judge wastes absolutely no time setting the tone. Before names are even sorted out, the court makes it crystal clear this is not a place for excuses, loopholes, or games. This opening moment instantly tells everyone watching that authority is firmly in control, and whatever comes next is going to be handled with zero patience and full accountability.
All right.
And Judge, we're asking for an adjournment. I just got substituted into this matter yesterday, Your Honor, and we're asking for an adjournment for discovery.
That's fine when appropriate.
During the matter, March 13th, 2025, 9 a.m. Yes, that's the bond.
Your Honor, I'm not sure, is the court in receipt of the bond violation report?
I am not.
I have not reviewed it either, Judge, but I'm certain what it would say. But
Your Honor, I have a report from February 24th of 2025 that the defendant had absconded from his tether and had been unable to be located, and they stopped supervision. I also wanted to address his jail before he got out.
Okay.
As the case formally begins, the tension quietly builds. Attorneys introduce themselves, dates are discussed, and the focus turns toward bond conditions. What seems procedural on the surface quickly turns uneasy when it becomes clear the court hasn't yet reviewed critical violation details. That uncertainty hangs in the air, signaling that something serious is about to surface, and the calm may not last much longer.
Do we have that?
No, we do not.
And you're aware of this?
I am, Judge.
And Your Honor, I also wanted to address his jail calls from before he was released.
Yes, go ahead.
In those calls, the defendant contacts a third party who then contacts the victim. The defendant says, I need you to do me a favor. So you have that number right, and the person says, whose number? He does, who is the victim. He says, I can't say the name, I can't tell you, but I need you to do me a solid. He said, okay, what? Tell them I'm thinking of you. And he says, the defendant says, y'all been talking, right? He says, no, I've only been talking to Peter, who's the victim. He says, can't say that name on the phone, because she's my case. And then in the next call, the defendant gets her added to the call. He calls the third party who then connects her to the call, and they're talking. And I also have concerns that he would be contacting her at a different number because I had a note from Detective Mosher that he had been contacting her as well at a different number. I'm just not sure exactly what that number is. And given the facts of this case, I'm extremely concerned.
Here's where things take a sharp turn. The prosecution outlines alarming allegations involving a cut tether, lost supervision, and indirect contact with the victim through jail calls. The details aren't speculative, they're specific and troubling. As the court hears how contact may have been deliberately routed through others, the atmosphere shifts from routine hearing to serious breach of trust.
And may I address all those issues, Your Honor?
Yes.
And so briefly, Judge, my client
Just so that I know, currently right now, he was ordered on a tether and he's not on a tether right now.
Absolutely not, Judge, and I'll address it. So Judge, if I may, so Mr. Hankey, he's 22 years old, Judge, has no criminal history whatsoever. This is his first ever contact with the law. Literally, Judge, 3 days ago, he admittingly cut his tether off. He got overwhelmingly scared. He didn't understand what he was actually charged with. He thought he was charged with a life offense. I told him no, it's a felonious assault. He was under the impression that he was immediately going to prison today because he didn't understand the law. And so he freaked out, Judge, and he indeed, admittedly, he cut his tether off. I immediately spoke with my client. I told him not to run, not to go anywhere, to address the court and to be upfront about it. And so, Judge, he's here today. He had every opportunity to not be here today, every opportunity to run, and he didn't. He takes full ownership for cutting that tether off, Judge. If I had talked to him before he did it, I don't think it would have ever happened. But Judge, I don't think he did it intentionally to, flee from the court. I believe he did it honestly, Judge. And if hear me out, Judge, I think this is a situation, Your Honor, where fear got the best of him, anxiety got the best of him.
The defense steps in and does something rare. They admit the tether was cut. Rather than denying it, they frame it as panic and fear from a young defendant overwhelmed by the system. From an outside view, this moment becomes less about legal maneuvering and more about damage control, as the attorney attempts to humanize conduct that already has the court's attention.
In terms of the jail calls, Your Honor, I would
Do we have the tether back?
Your Honor, I'm not sure, but I did also want to address that the defendant does have a juvenile adjudication for a CSE fourth and a dismissed DV from 2022, which the victim failed to appear as well.
Judge, community corrections have the tether back, and there's been communications with the tether agent and the office. And so, Judge, in terms of the jail calls, I was just made aware of those this morning. I would note that his the complainant in this case is his girlfriend. She's currently pregnant. I told my client to have absolutely no contact with her whatsoever per the bond conditions. And so, Judge, I make this argument, Your Honor, because honestly, I'm asking the court if they would give him a second chance. There was a $70,000 cash surety bond. That bond was posted. But for his actions 3 days ago, Judge, we wouldn't have this bond violation, at least with the tether. With the phone calls, Judge, again, I'm not saying he admits or denies that, but he knows he's not to have any contact, third-party contact with the complainant, and that will continue.
Just as sympathy begins to surface, the prosecution reasserts control by introducing prior history and deeper concerns. References to earlier cases, the victim's pregnancy, and repeated boundary violations reshape the narrative. What looked like a single mistake now feels like a pattern, and the court's patience visibly thins as the gravity of the situation becomes undeniable.
And so, Judge, I'm asking if my client could have a second chance on this tether. Again, Judge, he could have been like everyone else and just not come back or got caught.
We would have got him. I mean,
and you stole the words out of my mouth, Judge. I said, or he could be standing here today in a green jumpsuit, and he's not. He's here today, Judge, fully accountable for his actions. It won't happen again, Judge. I guarantee it. We plan to address this case, and I'm just asking for a second chance.
Counsel, all right, anything?
I just would kind of reiterate the facts of this case in which he pointed an AR-15 style rifle at the victim, saying to her, "I'm going to kill you. I'll put a bullet in your head." And then on the phone call, he addresses that he knows he's not supposed to be talking with her because when the other person says, "Who is the victim?" he goes, "Don't mention her. She's my case." So I have great concerns that he would still be violent.
He's playing the game. I don't play games. We don't play games here. You don't get to be put on a tether. Well, first of all, be told that you should not be contacting the victim and then finding and manipulating ways to do so. Don't do it here. Doesn't happen. Won't happen. And then when you get the grace, given the nature of the charges, to get let out, then you're running around and you decide that what the court ordered in terms of a tether, you decide you want to cut it off yourself. We don't do that either. Defendant's bond is revoked, defendant's remanded. I'll see him on the 13th, and counsel, you can give me your argument as to what I should do with his bond at that point, but right now he's remanded.
This is the moment everything collapses. The judge recounts the underlying allegations, including threats involving a rifle, and dismantles the idea that this was confusion or fear. With unmistakable clarity, the court makes it known that manipulation and defiance will not be tolerated. The ruling is swift and final. Bond revoked, defendant remanded, no debate left open.
Thank you, Judge.
Thank you.
Your Honor, there are two matters, and we would like to adjourn to look into a global resolution. There's a district court matter as well as the
Which district court?
14A4.
Okay. So why are you telling me that?
We're adjourning for global resolution, Your Honor.
But I don't have that other one.
You don't.
I only have the felony.
That is correct.
So why are you telling me about it?
So given the reason for the adjournment, we are.
No, I'll wait. It's going to be a long explanation.
Further negotiations is our reason for the request for adjournment.
I know, I see that on the form. So, all right. Chinaza.
Yes, sir.
All right. So when do you want this adjourned? So the other one is set.
Correct.
The other case, 1484.
You could have stepped in earlier.
Violence case, it is set for December 5th.
Got it. So you need this or after December 5th?
After is fine.
After the 5th. See, it would have been that easy. But
We said the same thing.
I don't know how you were leading with whatever you were doing. But
We said the same thing.
what?
What she said.
Even after the ruling, the courtroom doesn't settle. What follows is procedural confusion that clearly frustrates the judge. From an observer's perspective, it's a reminder that once credibility is lost, even basic requests are met with skepticism. The court asserts control again, signaling that organization and clarity should have come long before this moment.
No, you didn't. You really didn't. December 12th, 2024, 9 a.m. Bond will continue.
One aspect, when Ms. Shear was arraigned, she was not equipped with a GPS tether, despite the fact that we requested one. I am concerned that this case, that we have now 2 domestic violence cases and there is no GPS tether. I do know that there is a no contact order, as well. I would be requesting a GPS tether.
And Your Honor,
Go ahead.
the people did, Ms. Poisson did indicate that that would be their request today. When I spoke with my client, she indicated to me that that request was made at the arraignment. However, after arguments from both attorneys, the magistrate who arraigned her at the time indicated or decided that there was no reason for a GPS tether. There is a no contact in order. My case, or at least this case, was of January 2024. So she was arraigned, I think, subsequently on both of the cases when the new 14A4 matter occurred. So,
Well, when was the 14A4 matter? When did that one arise?
that it was Monday.
Paragraphs on Monday, so it's set. Sorry.
Of
Just
November 18th. This is January. So, and they were arraigned at the same time.
correct. I think the January instance, she was taken to the hospital, Your Honor, and then released, but she did not know that there was a warrant that had issued from that.
And that's this case.
That's our case, correct? Yes.
But I think the thing that I'm concerned about, Your Honor, is that we now have 2 domestic violence cases with this same victim. And so even if the magistrate didn't believe that a GPS tether necessarily was appropriate in a case dating from January, with the addition of a new case, I think that it's necessary at this point.
Well, what was the rationale?
Attention shifts to a related matter, and with it comes new concern. The existence of a second domestic violence case reframes everything the court has just heard. Suddenly, GPS monitoring and protective measures are no longer optional safeguards, but necessary tools. The judge's questions reflect a growing concern about repeated risk rather than isolated incidents.
You're saying it was addressed, but
Yes.
the magistrate's rationale in that I'm a bit perplexed by. Who's residing at the Valley Circle address?
We don't live there anymore. We moved out 6 months ago. 6, 7 months ago. No longer reside there.
Well, that's even more concerning because that's the only address I have for the defendant.
The address that is associated with the other complaint, the new case, is on Riker Road.
Right. Okay, I see that. So the Riker Road address is whose address?
That's where her family lives, Your Honor, her husband
Where?
and children. She was living there before this incident. Before the new incident, the 18th, the incident of the 18th.
Okay, so I get that on Riker Road, but then the alleged victim was there also?
That's her husband, Your Honor.
Okay, but he was there also? They were
Yes.
both living there?
Correct, Your Honor.
So where is this defendant is residing where now?
I'm staying in a hotel.
She's after the incident with the no contact order in place, Your Honor, she left from the home and she hasn't been there since her arraignment on the 18th. And again, the January.
So, and the alleged victim, her husband, is at the Riker Road address?
That is correct, Your Honor.
Now the court zeroes in on living arrangements, addresses, and inconsistencies. What may sound mundane becomes critical when safety orders are involved. From a neutral standpoint, this exchange exposes instability and raises red flags. When the court can't clearly determine where parties are staying, compliance with orders becomes far more questionable.
So who the
I think that's.
are you?
I'm sorry. Sorry, Your Honor.
Oh, no.
It's okay.
You don't just leap up and start yelling. I don't care who you are.
Gotcha. Well, I was just.
Seriously? Guess that's taken care of. Okay, so I guess my concern is that I do have the second one coming around, and they're located initially at the same address, but now not at the same address, but her address is temporary.
Correct.
And then I'm going to Home of New Vision.
Correct. That was the
What?
next thing.
A brief outburst breaks courtroom decorum, and the judge immediately shuts it down. This isn't just about noise. It's about respect for the process. The moment reinforces that emotions don't override rules, and authority in this courtroom is non-negotiable. The message is clear. Order will be maintained, no matter who interrupts.
She is slated to enter Home of New Vision on December the 3rd, Your Honor.
Got it.
So that's where.
Have that other.
Yes, so she's already gone through the admission, and the date that they have available for her is the 3rd. So she moves in on the 3rd from, yes, the hotel she's currently staying in now.
Okay. So here's what I'm going to do. I am going to order a GPS. I'll order it with exclusion.
If before the court does that, Your Honor, I do apologize. You did say it was going to be a long day. I apologize, and here I am.
Go ahead.
I know that the complaining witness is here today. My understanding is that there was going to be a request from us that there be a no non-consensual contact order in place. I know that the people have their own position on that. The complaining witness is her husband. They have children in common. They've been married for quite some time now. There were some issues at bay that may have led to these particular situations. Ms. Shear is working on that, hence the hospitalization, the treatment that she received there, and now her admission or self-admission into Home of New Vision. She's very.
I can stop you. I'm going to deny that request. I want to see how she's doing once you get in, how she's doing, because obviously there are, I'll just call them peripheral issues.
Okay.
So before I would let that happen, it's not to punish you or anything like that. Before I allow it to happen, I want to see where she gets in terms of that process.
Okay.
Okay, fair enough?
Yes, Your Honor.
I didn't care about you. I was talking to you. Oh, yeah, I wait for Mr. Janowski to carry. All right, so what I am going to do, though, is I am going to order a GPS tether with the exclusion zone being the Riker Road
So I will-
location tracking. Pardon?
So, okay.
She just wanted clarification that the GPS would prevent her from being able to go to Riker Road.
Right, and also we will have location tracking because she's going to be going into
And treatment. Sure thing.
I have a question. Is it okay if I go a couple hours away? Because I was planning on visiting my family.
You're going to be in the Michigan though, right?
Yes.
State? Yeah.
Okay.
She just wanted to know, she's traveling to visit her family, but it will still be within the state of Michigan. She just wanted to know if that was okay.
Oh, that's fine. That's fine. Okay. All right. Thank you.
Thank you, Your Honor. Okay. Should she go to community corrections now?
Yes, because I will be signing the order momentarily. We'll be good to go.
All right.
Okay. Yeah, so, ma'am, how'd you get here?
I got a ride.
Yeah, you did. Who'd you get a ride from? Come on back up to the podium.
I got a ride from Kayla Miller.
Yeah. That's a
Because I
problem.
was told he was allowed to be here today.
Pardon?
I was told he was allowed to be here today. And
By
I had
who?
no other way here
Who were you told that by?
by his family. I'm in contact with his aunt. Huh? Yes. I have no form of transportation.
This is a problem. Because she's violated the,
I didn't realize I was violating it.
let me do this. I'm going to pass the matter briefly. I'm not going to take her in right at this moment. Counsel, I'm going to allow you to explain to her the conditions of her release. And she's going to have to find what hotel are you in?
I'm in a Celine Hotel, the Hampton Inn.
Okay,
It's right down the street from my job. So I can.
gotcha.
job.
So I understand that, but she's going to have to figure out something else. So I'm going to allow you to sit and talk with her, but somehow or another, you're going to have to come up with a plan. If I'm not satisfied with that plan as to that, and there are people telling her things that are against her order, I'm going to have no option but to lock her up.
I understand.
But I'm going to give you a chance to talk to her about it.
Thank you, Your Honor.
The judge orders GPS monitoring with strict exclusion zones, attempting to balance accountability with opportunity. But just as things stabilize, a new issue explodes. Transportation to court itself may have violated conditions. From an outside view, this feels like the last straw. The court pauses, weighing whether leniency is still even possible.